Good evening, one and all. Today we are going to switch on our lecture series. At this juncture, I would like to Sri Advocate Ashishji Bajpai sir and all the faculty members. And even equally, I welcome to today's resource person, in charge principal Dr. Poonam Nathani madam. So today we are going to start our lecture series. So over to you, Mahajan ma'am, please. Mahajan ma'am.
Am I audible, sir?
Yeah, you are audible.
Yes, thank you, sir. Greetings to one and all, and welcome in the webinar, our lecture series organized by IQAC Department of Dayanand College of Law, Latur. It gives me immense warmth and great pleasure to grace all of your presence in the interest of the seminar being organized. Before we begin this seminar, I would like to express my heartfelt gratitude to all of you for sincerely committed to this event to make it a success. The seminars are organized and conducted to gain insight and information that would remain effective in our lives, exercises, and work. Topic for today's seminar is hostile work environment, an affront of right to equality and right to life, which will be presented by our in charge principal, Madam Dr. P.P. Nathani. I request Nathani Madam to please proceed for the seminar. Thank you. And I also welcome Dr. Advocate Ashishji Bajpai sir for this seminar. And with the permission of sir, Nathani madam to please start the seminar. Thank you, madam. Thank you, sir.
Respected Advocate Sri Bajpai sir, IQAC coordinator Dr. Dr. Panchal sir, Dr. Mahajan madam, all my dear colleagues, very good evening to one and all. First of all, before starting this program, I want to actually express my sincere apologies for causing delay and causing the interruption in this lecture series. Actually, it is not expected from my side. It would not have been happened from my side, but unfortunately it happened. I'm very sorry for the things which happened from my side, and I assure that in future it won't be happening from any of our teachers, sir. I'm very sorry for that, and I'm very thankful for giving me this opportunity to present this today's seminar. With the kind permission of Bajpai sir. Sir, shall I start?
Please start, madam.
Thank you, sir. Thank you. So the topic of my seminar is hostile work environment, an affront of right to equality and right to life. Very recently, the Delhi High Court gave the judgment that hostile work environment, it is really the violation of right to equality and right to life. The presentation will be concentrating on the new legislation, which is of immense significance because it aims to prevent gender discrimination at its most perverse form of sexual harassment at workplace. It seeks to secure for women a safe working environment where she can work with dignity, self-assurance. A law is enacted after 16 years of the judgment of Vishakha's case, a law which is very wide in their ambit and seek to cover the broadest range of cases, organizations, victims as is perhaps possible. By passing this act, we have reaffirmed our commitment to the international eradication of discrimination against women under the international obligation as well as constitutional mandate. In 2013, after the Nirbhaya's case, when the Justice Verma Committee was submitting the report, they observed that the right to be protected from sexual harassment is one of the pillars on which the very construct of gender justice stand. One side, when we are talking about the women empowerment, when we talk that they should come up and they should join the employment sector, another side they face the workplace discrimination. Actually, the safe working place, it is a legal right of women, not only the legal right but it is the constitutional right. The term sexual harassment, first time legally it was coined by the United Nations of America's court, when they said that it was coined by their court in 1975 onwards. Till that, there was no term existed. Legal concept was not there. So when they adopted the concept that it is violation of women's right, same thing was adopted by other industrialized countries like Australia, Canada, New Zealand, and other European countries. And it gained the sexual harassment. This concept gained popularity after 1975. In India also, after the Vishakha's judgment in year 1997, when it came up, that time also Supreme Court took the international norms for the reference which were given in the CEDAW, Convention of Elimination of All Form of Discrimination Against Women. That international convention standards were adopted by the Supreme Court while giving the judgment. Unfortunately, this sexual harassment, it is always excused as natural male behavior, which is harmless flirtation. Like that, we have the tendency, we have the mindset that always the women enjoy these type of practices. Actually, it causes these type of activities have serious harm. It directly affect the employability of the women. It also affect the productivity, and it impacts on the lives of the women also. Due to fear, they have the dropouts. The background, when we see about the sexual harassment, it is having the Bhavri Devi's case. We know the Vishakha's judgment, when in 1992 the social activist, she was gang raped by the upper class community male people, and she was very brutally gang raped and sexually harmed. That time, the public interest litigation was filed by the Vishakha organization before the Supreme Court. That time, they demanded that this sexual harassment at workplace should be considered as the violation of right to equality, because all the women should have the right to work and they should have the safe working conditions, and the employer should be responsible for upholding these rights. It was the first time in India where the Supreme Court laid down mandatory guidelines, and the responsibility of individual was shifted to the organization, to the institution, and to the employer. And here the employer was accountable for giving the protection to the female workers at the working places, and the priority was given to the prevention of the sexual harassment behavior, and the redressal mechanism was also constituted. The guidelines were extended to the employment, paid, voluntary, public as well as private sectors. After the 16 years of this act, in 2010, first the bill was submitted to the Lok Sabha and the bill was introduced. It was submitted to the Parliamentary Standing Committee for the examination, and after recommendation, with the subsequent changes in 2013, the bill was passed. If we'll see the overview of this bill, if the legislation is properly implemented and effectively, if all the stakeholders are implementing, it may play very crucial role in providing safety to the women. This act provides a civil remedy to women, and it is in addition to the other laws which are already there. About the criminal remedy, we have IPC provisions, even we have constitutional mandates, but it is an additional remedy, civil remedy given to the female worker. Now the question comes, what constitutes the sexual harassment? Now in this lecture, each and every aspect of this legislation cannot be covered. That's why only important area I am covering here. What constitutes sexual harassment? In detail, the definition has been covered. It includes unwelcome sexual behavior of direct or implied nature, such as physical contact and advances. Here chart is given. It includes physical contact and advances, making sexual colored remarks, demand or request for sexual favors, showing pornography, pictures, cartoons, unwelcome physical or verbal or non-verbal sexual conduct. In this definition, intention is not important. It doesn't matter what is the intention of the harasser. What is important? Impact is important. Second criteria is the behavior must be unwelcome behavior. If it is welcome behavior, it cannot be constituted as sexual behavior. What is welcome and what is unwelcome behavior? It is shown on the slide. If the worker feels bad, one-sided, powerless in control, if the behavior is unwanted, if it causes anger or sadness, if it is causing irritation, invading, it is unwelcome behavior. But if positively it is responded from another side, it is welcome behavior. To constitute the sexual harassment, it must be unwelcome behavior. Three things are necessary. First is, it must be unwelcome, it must be sexually in nature, and third thing is, it must occur at workplace. So second question comes, what is workplace? Before starting the workplace, I want to tell that the study, the development of the jurisprudence of sexual harassment in this area, it has made it possible to identify the forms of sexual harassment. What are the forms? Basically, two forms are there. Quid pro quo. It means, in simple language, if we'll see, that is blackmailing. This for that. It means it may be denial of any economic benefit to punish the person if there is denial from her side. Increase in workload, giving the extra work, denial of promotion, dismissal, force, resignation, implied or express threat about her present or future employment status. If you are not following this, that will be the consequences, like that. This for that, blackmailing. It is quid pro quo. Second form is hostile work environment. Hostile work environment, it is more subtle or it is more dangerous, where the person will create hostile atmosphere, intimidating atmosphere where she may not be able to work, which may be creating an offensive environment. Humiliating treatment may be given to her. It may not be causing the economic loss, financial loss may not be causing to her, but it will directly affect to her health or to her safety. That is hostile work environment, which was firstly coined by the United States of America. Their code, they have given this concept, legal concept. It was given in 1964 by the American Court in Equal Employment Opportunity Commission, which was established under Civil Rights Act 1964. During that time, they have coined this offense. These are certain examples of sexual harassment. It is not necessary that it should be verbal one. It may be verbal, it may be non-verbal. Here certain another examples are there. Verbal, non-verbal, physical and visual. Verbal form includes gender-based insult, some remarks, passing jokes, teasing, telling lies, spreading rumors, passing taunts, telephonic calls, requesting or demanding some favors. Non-verbal behavior includes steering, sizing up a person's body, derogatory gestures of a sexual nature, some suggestive looks, facial expression of a sexual nature, licking lips, stalking. Other forms are physical form and visual forms. Physical form includes unwelcome hugging, touching, kissing, forcible physical touch, molestation, stroking, grabbing, pinching, standing too close, blocking someone's path. Visual form includes presence of sexual visual material like posters, cartoons, drawings, calendars, pictures, computer programs, notes, SMS, MSM, emails, some passing some contents, written materials, sending emails, etc. These are certain examples. Pictures. Passing some comments, gender-based insult, forcibly physical touch, hugging, touching, singing some embarrassing songs, passing taunts, demanding some sexual favors, cracking jokes, making her feel some awkward, molestation, and stop this or I will complain, and making her or threatening her that if you are making complaint, I will stop your promotion. These are certain examples of sexual harassment. Now here one example is there regarding the sexual harassment. When the female they are coming out for the employability for doing the job, when in this 21st century, when we are demanding that they should come up and we should have, as we approach to the 21st century, we heard that the quiet steps of a rising revolution for gender equality. Women have greatly expanded their capabilities over the last few decades through a liberal in education sector. Mainly, we are providing good education to them. They stand ready and prepared to assume greater economic and political responsibilities. And whenever they are doing the jobs, nowadays in this 21st century, we have technological advances, we have the technological development, but still in this working sector, they have to come across all these hurdles. So many hurdles they have to come across. That's why we have to realize their problems. Gender justice, it is very essential to empower the women. Women, they constitute half the human resources. Augmentation of human resources is not possible without their empowerment. So to achieve the good result, all the impediments in the route must be removed sincerely. When we will see what are the causes of the sexual harassment, so many n number of causes are there. Maybe the power control, maybe the toleration. From long time immemorial, we are being tolerated these things. We have the settled mindset that these are non-hurting things. Maybe the patriarchal system, maybe the male priority or domination society, mindset of the people, masculine aggressiveness, socio-cultural pattern of our society, inferior job position, soft nature of ladies, or financial necessities, unreported matters which are giving more promotion to these type of cases. And another thing, the matters which are unpunished in the society, that are also promoting these type of cases. So what is the requirement? The need is we should come up to fight these type of cases to stop sexual harassment in the society. One Chinese visionary, he said that a journey of 1,000 miles must begin with a single step. So it is a time when we should rise one step to stop these type of things in the society. When this impact, it is not only the ladies or it is not only the female workers who may be suffering, but individual, employer and the society at large may be suffering. very bad and diverse and so many are there which are having which is negatively affecting the society. If we'll see the individual, what he or she may be suffering, that is the she may be suffering the she may be going through the mental stress, may be having the suicidal tendency after suffering the sexual harassment. It may be reducing her motivation and trust, and she may be losing the confidence and working capacities. She may be having the behavioral change. She may be suffering from the depression, isolation, and fear. There are the symptoms of withdrawal from the friends and family. There may be the dropout of jobs and schools also. If we'll see the impact on the employer, there is impact on low productivity. It will directly affect on the productivity of the employer. Absenteeism and lack of team spirit, poor image of the company. If we'll see the impact on the society, naturally it impacts on the unemployability. It will increase the unemployment in society when the female workers are forced to come out or drop out from the jobs. There is increase in the discrimination and effects on the dignity of women. Will be having the unsafe living and working environment which hindered the productivity and development of the society at large. It reduces the women participation also. Three areas are very important when we study the sexual harassment, this act. First is who can be called as employer, because certain responsibilities have been imposed on the employer. As I told you, when the act was enacted, the individual responsibility has been switched to the collective responsibility. It is not only the responsibility of employer but the responsibility of institution at large. So we have to study who can be called as employer, who shall be the liable to prevent these type of practices in their premises. So first we'll see the employer, second is victim employee, and third is workplace. These three definitions are very important. So it covers directly. I am switching to the picture. Employer covers three things: all the government bodies, workplace of government and local bodies, all the head or the supervisors or the officers specified are the employer of that workplace. They are responsible for prevention of these type of activities. Second is all the private sector is also covered. At private workplace, employer shall be the person responsible for management, supervision and control of that workplace. It also includes dwelling house, person who employs, who is benefited by that employment is called as employer. In short, the owner of that house is employer. Each and every sector is covered, organized as well as unorganized sector. What are the responsibilities? In short, 6 to 7 responsibilities are there. First is to create and communicate the detailed policy of prevention of sexual harassment. Second, to display the penal consequences of sexual harassment. Second, to create the awareness and orient each and everyone by organizing workshops and sensitization programs. Constitute internal complaints committee in every workplace. Second, all the members of that complaint committee are to be trained properly. Next, annual report should be submitted on time. Next, when any complaint comes, it is a duty of employer to give his full cooperation for the completion of that inquiry, and treat sexual harassment as misconduct under the service rules, and provide each and every type of assistance to file police complaint whenever it is required. Under the legislation, penalties are provided for the employers also. If employer fails to constitute committee, he'll be penalized for 50,000. If he fails to act on the recommendation on the complaints committee, if he fails to file the annual report, if he contravenes or abet any of the provision of the act, he will be penalized for 50,000. But when there is repetition of the breach, the punishment will be increased. Even the license, there shall be cancellation of the license or withdrawal of the license, or the institution can be stopped. Next is kinds of employees who can file complaint under this act, who can be called as an aggrieved women. Which ladies are covered to make an complaint? In this chart, it shows that each and every type of employee is covered. As in starting I told you, it is wide enough. It is having very wide ambit to cover the broadest range of cases. It includes regular, temporary or ad hoc employee. It also includes the employee which is appointed directly or through an agent or contractor. The person, the female worker which works with or without remuneration, or which works with on voluntary basis. The worker, employee which is appointed expressly on express terms of employment or on the implied terms of employment, who is probationer or visiting member. Even the students are also covered in the definition of employee. Suppose in the college premises any sexual harassment happening, students are also covered under the definition of employee, and they can be benefited under this act. Not only the teachers, not only the staff, teaching, non-teaching staff, but students are also covered. Same way, the wide definition is given for the workplace also. Even workplace covers organized as well as unorganized sector. It also includes extended workplace, where the office parties are conducted, offsites, where the trainings are given, even the client meetings are conducted outside the premises also. It is being covered. Travel for the office purpose, that traveling places are also covered. In this picture, all the workplaces are covered. Government owned or controlled establishments, hospitals, nursing homes, vocational educational institutions, dwelling places in cases of domestic workers, sports institutes, stadiums, training institutions, private organizations, everything. So wide definition is given to workplace also. It is extended workplace, where the office parties are conducted, offsites, outbound trainings, client meetings, training sessions, travel for office purposes, or any place where one visits in the course of due to employment purpose. Another thing is, the main objective of this act is prevention, prohibition and redressal. Last one is redressal mechanism. Two redressal mechanisms are provided: internal complaints committee as well as local complaints committee. So two mechanisms are provided. For internal complaints committee, at least 4 members are required, and local complaints committee, 5 members are required. At district level, this local complaints committee is to be constituted towards the collector, district magistrate, and where the employees are more than 10 workers, their compulsory internal complaint committee is to be constituted. Here the constitution of the committee is there. Mandatory for establishments employing 10 or more employees. Excuse me, one second. Am I audible?
Yes, ma'am.
Yeah, you are audible, ma'am. You are audible.
So this is a constitution of internal complaints committee. Presiding officer shall be the senior woman of that institution. 2 members shall be the outside members who shall be having the special knowledge or experience in social work or legal knowledge, and 1 member from NGO or other organization. It is the constitution of internal complaints committee. And local complaints committee, it is at the district magistrate level. It is mainly for the unorganized sector, where at every level they cannot constitute. So for district level, local complaints committee is to be constituted. It is to be set up in every district by district collector, and local complaints committee is the grievance redressal body with respect to organization having less than 10 employees and organization that have not set up an internal complaints committee. So suppose any complaint any domestic worker wants to make, they can go towards the district magistrate office, they can make the complaint towards local complaint committee. The procedure has been given that within short span of time, the procedure is to be completed. Time bound period is given for completing the inquiry and submitting the report for taking the action also. When the incident of sexual harassment is happening within 3 months, the complaint should be made, and within that 3 months, inquiry should be completed and the report should be given. If beyond that time it is taking, reasons for delay is to be recorded in writing beyond that. Here one requirement is there: when the matter is going for the settlement, it should not be settled in monetary form. In monetary way, matter should not be settled, and it should be recorded in writing that why it is being settled and how it is being settled. These are the complaint mechanism. These two mechanisms. Time bound period is there. Any aggrieved woman may make in writing a complaint of sexual harassment at workplace to the complaints committee within the period of 3 months from the date of incident, and in case of a series of incident, within a period of 3 months from the date of last incident, and if beyond that time it is being filed, reason must be specified, and the reason for non-filing the complaint should be given. If the woman is unable to make a complaint in writing, assistance must be provided. The complaint must be given in 6 copies by the aggrieved person, and it should contain all the material relevant to the matter, which should contain all the following details. Who can make the complaint? It is not necessary that woman herself should come and make the complaint. Her relative, friend or special educator, any social worker, any outsider, but with the consent of that woman, he or she should get the consent in writing from that woman for making the complaint, or the guardian under whom she is receiving the care can file the complaint. In case of death, any person who got the consent from the legal heir can make the complaint on behalf of that woman. Even the interim reliefs are also available against the women in case the allegations are proven, because it is civil remedy. If we will see about the criminal remedy, court proceedings will be there, but it is the civil remedy. That's why if the case is proved, it will be following the service rule, because as per the service rules, it is the misconduct. Disciplinary actions can be taken. Even the written apologies are accepted. Warnings can be given. Their increments can be stopped. Withholding of promotion, withholding of pay increase or increments. Counseling sessions can be conducted. Even the community services can be extended. Termination from the services is also permitted under the Act. Financial damages or additional recommendation to address underlying the factors. Here the timeline is given. Submission of complaint within 3 months of the last incident. Notice to the respondent should be served within 7 days of receiving the copy of the complaint. Completion of inquiry maximum within 90 days of the complaint. Submission of report by internal complaints committee or local complaints committee to employer within 10 days of the completion of the inquiry, and implementation within 60 days. And it is extended when the reasonable causes are there. Determination of compensation. When the compensation amount is awarded, these all factors are to be considered by the committee: mental trauma, pain, suffering, medical expenses, income, financial status, and other things. Apart from the civil remedy, criminal remedies are available under Indian Penal Code, mainly under 2013 Criminal Amendment Act. When the Burma Committee said, the following changes were brought in the Indian Penal Code. Section 354, assault or criminal force to women with intent to outrage her modesty. The punishment was enhanced from 3 months to 5 years. Now the punishment is, which shall not be less than 1 year but may extend to 5 years, and shall also be liable to fine. It is cognizable and non-bailable offence. 354A, sexual harassment and its punishment. Criminal remedy in specific offence, it is available under IPC, and the punishment is, which may extend to 3 years or fine or both. Previously this punishment was not available. 294, Obscene Act and Songs. 509, 354B, assault or use of criminal force to women with intent to disrobe, voyeurism. Section 354D, stalking. Before concluding, I want to discuss here about the Me Too movement, which began in October 2017. As a hashtag, it was started by American actress Alicia Milano, who shared her story of sexual assault against Harvey Weinstein. We also heard Indian cases about Tanushri Datta and journalist this MJ Akbar. Last time only, when in Delhi court criminal defamation case was filed for this Me Too campaign. In India also this movement was took the flight. Tanushri Datta, she also spoke and tweeted that Nana Patekar. So many stories came up, actually each and every name I should not want to take here, but this movement has brought to the light many stories of sexual harassment, that how the abuses came up in public domain and how the name was came. Actually, what is the legal status of this Me Too movement? These are unverified stories, and directly we cannot spread these things on social media without any proof and without the court judgments and everything. So it may give rise to the criminal cases, defamation cases also. But it is showing that now Indian women cannot, they can no longer ignore the scope of this problem. Now they are aware. Now they are coming up in 2018, but somewhere it is being misused also. In 2018, the case was filed against, allegation was filed against the Chief Justice of, the then Chief Justice of India also. But this matter was of great public importance, which touched the independence of judiciary. 3-judge bench sat and they decided that whether the complaint was fabricated and it is motivated by the conspiracy to undermine the independence of judiciary by the corporate person or by the political leaders. That time, 2 committees were framed. In-house panel committee, where they want to investigate whether really the sexual harassment allegations are true or not. And secondly, retired Justice A.K. Patnaik, their committee was also formed to see whether any conspiracy is there for filing this allegation. So these 2 type of panels they constituted, and at last they concluded that there is no any substance for having this allegation. That's why they withdrew. And lastly, before giving the conclusion, the complaint was withdrawn also. It was withdrawn by the complainant. So both sides are there. But lastly, recently only in 2020, Delhi High Court said that women has right to put her grievance even after decades. Delhi Court acquitted Priya Ramani in MJ Akbar's criminal defamation case when she tweeted in hashtag Me Too movement that she was being sexually harassed by MJ Akbar. He was the union minister that time. So these are some cases which came up, and the stories which brought many controversies in the society. When we'll see these type of cases, the situation when the women are coming in the public domain and they are working but they face these type of issues, certain recommendation I want to put here. If we are giving the proper implementation to this act, definitely we can stop these type of practices. If internal complaints committee and grievance cell is established and working properly, if it is set up at each and every institution, definitely these it will help in curbing the sexual harassment at workplace. Proper training should be provided to the committee members. Sensitization program should be conducted. Periodically, meetings should be conducted. And most important thing, we should adopt zero tolerance policy not only by the employee but employer as well. We have to communicate the whole staff about the prevention and redressal policy. We have to encourage women friendly culture at workplace, and we should receive complaints, and with full assistance we should investigate the matter with seriously we should investigate the matter also. Maximum job opportunities and promotions should be reserved for women, and legal awareness programs should be conducted. Now it is a time when we have to change this traditional socio-cultural mindset of the people, where we have to change the role relationship of men and women. We have to strengthen the women empowerment not only by the education. Various modes are there for empowering the women: political, social, cultural, economic, educational. But employment is also the way through which we have to empower the women. Easy access of women to justice, it is the another area through which we can empower the women. Women related studies and laws should be, these subjects should be compulsorily taught at the elementary and secondary school students. We have to enhance the education and employment opportunities, enhance the role of non-government organizations and medias, and specifically these type of legislation should have the proper implementation from all the stakeholders. Then only we may be getting the proper implementation of these laws. So it is well established that ensuring safe working condition for women leads to a positive impact of their participation in workforce and increases their productivity, definitely which will benefit the nation as a whole. Economic empowerment, I personally feel, is a key to the development of the nation. Thank you. If any question anybody want to ask, it is open.
Yes, appeal to the faculty members. If you have any doubt, please raise it. Okay. Now, time for Dr. S. Mahajan and all the faculty members. Very good evening to one and all. This is my great pleasure to propose vote of thanks. At this juncture, I would like to thank from the bottom of my heart to Advocate Ashit Bajpayee sir for sharing time with us, motivating us for continuing the lecture series. Sir, you are really instrumental for conduction of all such curricular activities in our college. Equally, I thanks to today's resource person, Dr. Nathani madam, for very comprehensively placing before us the very significant law to prevent sexual or harassment contains number of graphs and images and the very scheme of the place and enlighten us who are employer, who are employee, and what does it mean working place, how the mechanism workplace to prevent sexual abuse or harassment at the working places. Penal provision, including penalty of interim very reform, madam, through PowerPoint presentation at the lecture. So at this juncture, I thank to ma'am for enlightening us on the various pages of the um, life and journey of the woman at the working places. Equally, I thanks to Dr. S.A. Mahajan madam for welcoming the guest and the resource persons and faculty members. And at this juncture, I would like to thank to all the faculty members present over here and who participated actively. And finally, I thanks to Rahul Chauhan for streaming the lecture on YouTube with the permission of the chair, with the permission of the in-charge principal. I declare the today's webinar or lecture series or lecture is over. Thank you. Thank you very much.
Thank you, sir.
Thank you, madam. Thank you.